sort of well established.
Yeah.
Well, good afternoon, everyone. We're starting back up here.
Is this the clean version?
Yeah. So I've started a clean version to start incorporating your comments and suggestions into. So I don't have the original red line version. I'll have it so you can move off of it, and I've tried to commemorate your comments and edits in this version here. The first one I did was alter 1A to read Ocean Renewable Energy Projects, comma, which includes, etc., all associated structures above, as you can see on the screen, to sort of streamline that and incorporate some of the edits we heard and then delete it.
So
we will send this out to everybody for a review. And Joanne, what's up?
I do this too, you know. So it's like, which includes all ocean renewable energy facilities, equipment, or all ocean renewable energy facilities and associated equipment and structures. So you're you don't describe. So when you describe the associated equipment and structures, you're limiting yourself. I'm just saying. So it's not. They could say, okay, well, it's not like was mentioned before. It's not monitoring equipment. It's some other kind of equipment. It's all associated ocean renewable energy facilities, equipment, and structures. That simple. That's my suggestion. When you start describing the getting into detail of what that equipment and what the facilities are, and what you already said that they're all associated with ocean renewable energy project. You don't need to describe specifically, I don't think, unless you want to.
Your suggestion is to remove monitoring.
Exactly.
And then the definition too. Well, because there's a definition of monitoring.
Yes, right, exactly. Because that's.
I'll just have that as a suggestion.
That's a suggestion.
What is A now trying to say? Oh, it's saying these rules apply to A.
Yes.
So you don't really need an A then.
No, you're right. You're right. I don't mean that.
Here's this guy.
What is this? Temptation.
That one is peanut butter. Pure yumminess. Chocolate's coming on.
It's a crash in half an hour.
Yeah, that looks yummy.
Are we hanging on to the caramel
A
and
little slice of heaven there.
1:30?
Oh my gosh. Indulge if you dare.
I'm not gonna do it. I'm not gonna do it. I might do the other one. I'm gonna do what I'm gonna do and go for the extra good one.
I don't know who brought this, but thank you.
Yeah, thanks.
Thank you, Scott.
Who's payroll in our office?
That's my motto today.
So are we good on scientific equipment for now? Where would we like to start back up here, folks?
Well, can I just ask a clarifying question? When you ask us questions like that, Chris, are you asking us to like sign off forever and always on this today? No. So you're just asking if anybody else has a something they still need to say about that.
Absolutely, yes. We will at least have one more RAC meeting to consider these rules. And what we'll be considering is if they're in a form that's ready to go out for public review and comment. Frankly, we're not saying these need to DOJ yet, so actually we might get back from DOJ and they might tell you guys are insane. In which case I'll bring it back to you. I will bring it back, but we might not necessarily have a meeting, but I will send it out to the RAC ahead of time and solicit comments.
Well, that's a good point. So DOJ hasn't even reviewed this yet. A lot of this will get knocked out by DOJ, I would think. Redundancy, things like that. So is there opportunity for this group to look at it after DOJ, like scrubs it?
Yes.
We shouldn't have
two things. Let me finish that one more time.
Yeah.
We might not necessarily convene for another RAC meeting at that point, but yeah, we can send it out to you ahead of time. And so DOJ will review it, prior to it going out for public review and comment, and then we'll reflect on the public review and comment.
I guess what I'm saying, Chris, is I would prefer I mean, yeah, I appreciate this, our comments, but I wouldn't want to see it again until after DOJ reviewed it. Let me just say that for final comment for this group. But I understand you probably want to have final comment for this group and have DOJ sign off on it.
But it wouldn't be a final comment at that point. We'd have one more round.
Because a lot of this stuff DOJ is going to knock out anyway. Because it's, So I would prefer having the DOJ review and then, you know what I mean? Not
Sort of, yeah, I think I understand what you mean. That's why I would like to get some of the substance questions too, although we want to get to the precision. I know we want to have precision language. And you know what? I was trying to incorporate the changes we come up with today and send you guys a Word document. And you can get me some track changes, comments, or questions as well. We're still months away from public review and comment. And DOJ's review might take a while because our attorney is not versed in the territorial sea. We might have to subcontract it out to Mr. Shipsey. And I don't know what his schedule looks like either. But for today, I still want to get through some of these topics and make a new, work on a secondary draft. And remember, when this group's work is done, initially, it would be, we just want to have a draft that's ready, but you guys think it's ready for the public to review and provide additional input on. And including RAC members. So if you see something you don't like, and you can send him a comment period, public comment period too.
Okay.
Just, I think it's your OA on, for God's sakes. It's probably you're whoever you're working with at the AG's department is probably the most important person here. But people that I don't care.
Well, you guys are a group of interested and informed stakeholders. I really want to get your input on this. On different sections of the rule, I think I get it. I don't know if we're on the same page here with the scientific experiments, but I'm feeling okay about it. And I would like to get to some of the other...
But Chris, is that true? When the AG goes through this, they're just looking for things that, are somehow controversial to existing staff. They're not going to do the policy, they're not doing the course, they're not doing the policy.
They are looking at the legal sufficiency.
Yeah.
Making sure we're not saying anything that's not constitutional.
Contradictory.
Yep.
So I'm content with the language as it's drafted, and I think it would be nice to see the final language, the penultimate language, that we can be fresh minds and look at it again and make sure it says what we wanted to say substantively. So unless Scott had something on that, I was ready to move on to my next underlined word, which is a number.
I wanted to go back to 3A. And I apologize for being late.
3A, these rules do not apply to.
Yeah. So if you skip down to the second line under 3A, and submersible land and territorial sea that are not related or supporting structures. And I just thought, for clarity, do we want to specify what it's not related to? If it just says not related, I think that leaves it just seems like it isn't a very clear sentence by just leaving it open-ended, not related. I think we all understand what's meant there.
Not related to the project?
Yeah, not related to the project would be, I think, a better choice.
Docks infrastructure.
I was going to say not project related.
Okay, project related, sure.
That'd be right here.
Thank you.
And then get rid of the rest of it.
No, I just wanted to so that it qualified what it's not related to.
Is it redundant to have project related? I mean, the supporting structure would be project related, right?
Right. It
So
would,
I can
You might.
delete from here. What are you thinking?
well, I wasn't thinking that. I was thinking,
Right, that's what I thought.
Related to what was your question?
related to
So project is
Supporting structures would be project related.
Yeah.
Right.
I think that captures enough project related. But you have the same basic language in the next sentence.
Yeah.
I'm seeing that too. If you
So
have
you
that
might-
related down below as well.
And what does it say in 141082? Because it says facilities or structures which are not defined as related or supporting structures are governed by the, oh, okay, never mind, sorry.
Yep, those are our standard waterway authorization rules.
Okay.
Waterway leasing.
Does that define related or supporting structures? Is that defined somewhere,
I'm not sure.
that wording? I'm just wondering if that's,
I didn't know.
I can,
There's some of this is in the,
oh,
We might make a note just to make sure there's not a definition of those things in that OMR.
structures, facilities, or structures which cannot.
And
Yes. Scott?
And in C, cables, 3C. So I thought we had discussed this, and I thought we were all in agreement that cables that were, transmission cables coming to shore, for example, would be under Part 4. But we have sort of the language here is a double negative, granting renewal of easements for cables that are not related to facility authorized under these rules.
Yeah, so basically this is for a cable coming in from sets, let's say. So there's not an ocean energy lease that's going to be required because it's outside of the territorial sea. So we're saying that these rules do not apply to that cable coming across the territorial sea.
That cable will be under Part 4.
Yes, and our cable easement rules.
Right.
Yeah, 83. Is that, yeah, that's there. But just so you know, Scott, later on in the conditions section, we did talk about the cables that are associated with an ocean energy facility and how they are still subject to Part 4, which was an addition based on some of the work you guys asked us to do, and we added to that. We discussed in that memo at the last draft meeting. Jason, did you have something you wanted to?
If we're moving on,
I just want to point out, I don't see anything in 82 that talks about related or supporting structures.
Okay.
So it seems whatever we want to do.
Okay, thank you.
you ready?
Yes, sir.
Next page, subsection 7 and 8 both refer to providing a right of first refusal for someone who at 7 has a 125 lease, and then under 8, 140 lease. So moving from a scientific research project to a demonstration project, or from a demonstration project to a commercial project. First of all, I think it's good that you have the first right of refusal in there. First right to apply. The only question I have really is this number of 30 days. I would suggest that unless there's a reason that you want to kind of keep it so tight, 30 days, why not make it a little bit more flexible for an applicant? They may not really know until they maybe pulled gear out of the water whether it survived or worked as well as they wanted it to, and they may need more than 30 days to be able to claim that first right to apply.
I will make a note of that for now. So you can see in your red line version, there was existing language with regards to first right to apply, and that was 30 days prior. So I just wrote this to mirror that. I'd be interested in hearing. This is kind of substantive, so I'd be interested in hearing what folks think about that. But I can certainly make a comment for now. There's a suggestion that the first right to apply be broadened.
Is this temporary use have to go through JART? Does this temporary use have to go through the JART process?
The deployment of the initial scientific equipment does not under 125, but the temporary use authorization that you would have to deploy a device will be going through JART. Yes.
For the research projects?
Yeah.
So under 7, it goes through, doesn't go through JART. Under 8, it does.
Yes.
Okay, so I would tie the. I'm just responding to your getting clarification on 7 and 8. So I would tie the deadline to whatever review period it takes the JART to get through this. And if this is a review period for that, then the JART review period would be substantially less than this. You have to have it both ways. Can't have it one way.
I have a clarifying question on that.
Yeah.
So, if we're talking about an instrument, what kind of a time frame is typically used for an authorization for an instrument? Because this is 30 days after that authorization expires. So do they say, it's a 1-year authorization for this science instrument or a 5-year? Because it may only be, I kind of saw that 30 days, but I thought, well, maybe they put it in for a year, but the authorization is for 5 years, so it never would reach the expiration if it was something like that. But is there a typical time frame for these scientific instrument authorizations?
Jerry, how long are the special use licenses?
Licenses, I think, are 3 years, 5 maybe at the most. I think they're 3.
So maximum of.
Max.
But each one is on a sort of a case-by-case basis.
Right. Like we had, the one is for a year, and, and that's what they request. So that's their project is 1 year. And it can be terminated sooner if they're like, we're done, we have enough information.
Okay.
Is that stuff?
Go ahead, Carl. I got a second.
Well, so I just want to, say that the only concern that we would have with that is if the approval results in a regulatory or de facto closure of a certain area, and there's other ocean users that want to get back to business in using that area, then we want to have some, fair and realistic and practical expectations on what the first right to apply does, and a 30-day period seems fair to me, given that if I'm serious about moving on in the next step of the process, I probably already know that well before my permit expires. And all this says is that I need to notify DSL, I believe, so all I have to do is notify DSL that I intend to exercise my first right to apply. And so I think that's perfectly fair, and in fact, I think that drawing that out longer would be unfair to other ocean users, or could be unfair to other ocean users.
Two responses to that. One, the language suggests that the first right to apply shall expire if not executed within 30 calendar days of the expiration date of the special use license. And presumably, if the special use license is expired, then the gear is out of the water. Therefore, any subsequent users would be free to use that space in the interim. Secondly, I don't know that 30 days is enough. It's an arbitrary number. I don't really know, unless there's kind of seems to me a good reason to restrict it to 30 days, and if the area is open because the gear has been taken out, then other users are allowed to use it. Then I don't see any reason why we should limit it to 30 days. Any other number, 60, 90, something that gives a little more flexibility. We're talking about a decision to spend millions upon millions upon millions of dollars to do the next project, to gear up for the next one. And I've never made that decision. I've never been in that process, but I suspect it's made through a lot of
So if they're considering it, then they tell DSL that they intend.
And so the other question about that was, how long, if they call up Chris, say, hey Chris, we're going to go with this, how much time do they have before they've actually got to do something substantive, like start writing checks?
Let's see. So I believe we tried to work that out in the preliminary application process, sort of flush out what we need to do. And that was based on earlier conversations in the RAC 2 and the memo that was drafted up at one of the earlier RAC meetings. So let's see. So if the department receives, so this was about the first right to apply, sort of like a preference right. You would have a preference right. Department shall provide written notice to the holder of the application. within 60 calendar days from the date of the written notice from the department, they must provide written notice of the holder's intent to exercise the first right to apply. So the way the first right to apply is written is very similar to our preference right language in our water releasing rules, which comes from statutes for water releases.
I heard 60 days in that statute,
Yep,
though, not
60
30.
days.
What page are you looking at?
I'm looking at page 8 of the red line version. Sub 8, which is about halfway down the page.
And is that calendar days? Did it say calendar? Usually
It did say
state
calendar.
operates in business days, but yeah, that's
It's a
interesting.
calendar. So, and this is all suggestions,
Yeah.
right? This is all brand fresh language. I'm open to discuss this. This would give, so if somebody, if you had an authorization out there for something, and someone else submitted a preliminary application, you would send that preliminary application to the holder, as long as they're a holder in good standing, and give them 60 days. We're proposing to give 60 days for them to provide a written notice of the holder's intent to exercise the first right to apply and submit a preliminary application. So then they got to submit their own preliminary application as well.
So these two numbers really apply to they're two different standards. They're not inconsistent. You got to notify DSL that you intend to exercise your right within 30 days. And then if somebody comes along and says, hey, that doesn't make sense, because if you've exercised your right, you've exercised your right. And it doesn't matter if somebody comes in behind you.
How's that?
Well,
Because the permit's vested with them.
yeah, you're vested. So even if somebody comes along and says, oh, no, we're interested in it too, it doesn't matter, because the other person already exercised their right to go forward with section 1. Yeah. So the only thing this could suggest is that you're going to go back to the first applicant. Do you really mean it? And you've given them 60 days to do that, to make that decision, and initiate the JART process or preliminary permit.
They have the opportunity to submit a preliminary application at that point.
It's a little weird, but okay,
Okay,
I understand.
So yes, we did. Joanne, actually, we did 60 days. I think this originally, if I'm thinking back to the memo, I had 30 days and then 120 days to resubmit your preliminary application if it was not.
And so once you submit your intent to have first the right to apply, you would then, after that 60 days or within that 60 days, have to actually submit a permit?
A preliminary
application.
Yep.
Which has fees associated with it.
Yeah.
Which would then go through the JART process and so
Yeah.
forth. And so, okay. So then they would have to be ready to go on the next step, really. It doesn't make sense. It's not. So.
So that's 60 days right there, triggered by someone else's interest in the site, means that they've got to submit their preliminary application for the 140 lease within 60 days.
Which means someone else has a preliminary, like maybe a project ready to go. They're submitting a preliminary application too.
Well, it says that if the department receives a complete preliminary application from another person, you're right, so they did submit a preliminary application. So I have no qualms. This does anticipate the situation if somebody does come in. The first guy might be say, you know what, we didn't really mean it. Fine, go with the second person, but I have no qualms with that. But I do, going back originally to the 30-day issue, is I'm a little uncomfortable with the 30 days. I mean, 60 is better than 30, but it's not a huge issue.
I think all the days for compliance with all this in here should be consistent. Going from the applicant's requirements also to the regulatory review dates. They should all be consistent, to be fair.
Scott's had his tongue up front.
Go Scott.
It's going back to sort of a different subject on number 7. Number 7 and number 8 differ in that number 8 talks about an authorized area, where number 7 just says they have first right, but it doesn't say that it doesn't specify that first right applies to the area where the research was held. So I think those two passages should be consistent also. Is there a reason that that's not in?
Probably not. Let me take a quick look at it.
So the first, shall we give the first right to apply for temporary use authorization for a demonstration project under these rules? Technically, that says if you do this scientific work, you have the first right to apply anywhere in the territorial sea.
Okay, so we'll make sure we,
So, but in number 8, it says in the authorized area. So it seems like those two should be the same.
That's a little weird too, right? Because the original 125 would probably be for one single measurement device, and so the authorized area associated with that device is going to be probably pretty small.
Right.
although we go on to describe later on your first right to apply, your first right applies to
Under 9.
no larger of an area than 0.25 nautical miles by 0.25 nautical miles. On page 8, yes. Just going back and forth. Yeah. So maybe we actually don't need this language. If we're going to describe the first right to apply section further on, maybe we don't need this in applicability and purpose. Number 8 was original language from the rule that was in there. So I felt compelled to put 7 in there to show that we were making the same concession for a scientific experiment.
I think you want to keep it in because it goes to the extent of rationing of the investment. Just demonstration project and demonstration project.
Okay.
So I have one more issue here.
Authorized areas. One second. I'm trying to figure out where to put that authorized area. Let's just write it in.
Scott, are you done?
Yes, I'm sorry.
Who's next year?
Jason.
So what this language permits is for somebody to have a 125 permit to have first right to do a demonstration project, and allows somebody with a demonstration project under 140 to do a commercial project, a lease.
Yes.
What if you deploy a 125, you get a 125 because you want to test the wave energy in that area, and once you've concluded that it is above a certain height, you're willing to do a project that is not a demonstration project, you're ready to do a commercial project. Do you not get a first right of refusal?
Good point. I don't think we ever specified that it had to be a demonstration project.
Yeah. I mean,
Although, I think Part 5 discusses taking a precautionary approach.
It does.
There was not a path forward at all before for the first right to apply for a scientific experiment. You could deploy it and apply for a lease, and you could still do that. This path forward gives you that first right of refusal or to apply to go from step to step to step, which I kind of thought was consistent, which I think is consistent with the policy set forth in Part 5. Doesn't mean you can't go straight from deploying scientific experiments, data collection to monitoring to a lease. But right now, it doesn't state you have that first right to apply.
I see the logic. It gives me heartburn, because what if we're we've deployed 3 times other places, we're ready to leave something in the water for 10 years and truly make it great. We're not going to put 10 of them out there. We want to put 3 of them out there. It's not a demonstration project anymore. We got money to do this. We want to sell the power to whomever. That wouldn't give them the first right of refusal, and that was sort of where all this started.
So where does it say that they couldn't interpret this that way, though?
Because it says for the temporary use authorization, which applies to temporary use, applies to demo project, right?
Demo project. So temporary use and demo project.
I don't think Part 5 requires you to do it expresses a preference for the phased approach, but it does not require
I think this goes back to some of the earliest conversations we've had here. As a practical matter, if you are real and you have a decent technology and the ability to deploy, and God knows if you have a power purchase agreement, which is not easy to get, who else is going to try to elbow you out of the way for that site at that point? And your agency, I think, already inherent in the rules. Aren't there sort of capacity requirements? You've got to be able to look at the permit and say, if you don't, then I think you should have it in the later part of the process, which is spell out some criteria about what makes a realistic applicant. Because we can't speculate. Who knows? Maybe there will be different firms with different devices that actually have power purchase agreements. We can't. There may be a day where there might be multiple competitors for sites where that would really matter.
And I'm pretty sure we have language in here about having the ability to evaluate competing applications and choose the one we think is most appropriate based on our policies and reject the other. But I can look for that. It's kind of hard on this.
I think that's important because that gets back to the how do these things sort of start being this and turn into that.
So, Chris, just in that hypothetical situation where you have multiple applicants and the agency has to determine which one goes forward for a specific site that both are interested in. Yeah, let's say you have one that has this first right, maybe didn't do the first right thing because they didn't do a demo project, but they were there first doing scientific work. And then you have another applicant who maybe has better financial backing, stronger company, better history.
And a PPA.
How do you we don't want it so that they have to go to the history. They had their science instrument there first, but they didn't follow through with the demonstration project. I guess I would say I'd like the have the ability to pick the best applicant, not necessarily the first applicant.
Okay. So
just in your thinking, how does that work with this state's evaluation?
Is there language somewhere that you can point to where you would go through that sort of that logic, or what the provisions would be for the state assessing the various applicants for whoever you conceive as being the best applicant?
Well, the preliminary application process section,
which is
it is on page 8. It is OER 141. 145, so we've got this notwithstanding the first right to apply. So it's still, and the whole process, the purpose of the first right to apply is to give that person, as long as they've made up clear in good standing, an opportunity to continue to develop the project at that site. So notwithstanding the first right to apply, if more than one application for an authorized area is received by the department for the same or conflicting uses, the department reserves the right to determine which best proposed use best fulfills the policies specified, which we went over the policy earlier, and accept and proceed with that application and deny the others.
Because you could get in a situation where people start doing site banging, which Lincoln County, of course, years and years ago was accused of trying to do.
Right.
But you don't want someone camping out. So, I'm going to, and it happens all the time in the private sector where people buy properties or establish relationships with other companies just to make sure somebody else isn't. Mm-hmm. And so, that kind of open-ended language, if you're real and you're ready to do something, then I think even the language you're suggesting would grant you the ability to separate out someone who's just camping out there or trying to keep a competitor out of Oregon type thing.
I think so, but nevertheless, it still says notwithstanding a first right to apply. So we want to be able to give somebody, let's say it was M3, maybe smaller, a chance to, if they've been continued to be a holder in good standing, the opportunity to move forward with their project, even if, right? I mean, if you're going to have the first right to apply, even if Pacific Power comes in with a big build out, and then you have more wherewithal. Do we want that first right to apply in there? or just for the agency to
Well, I think
to
if
evaluate competitive
If they
projects?
follow the steps for first right, then we have to follow that. You can't just say it doesn't apply. But if it's simply a matter of the state choosing, because they didn't follow this process to get it state, then I would say the state needs to make a judgment based on the strength of
Overarching
the
policy.
So, of course, in a leasing program like the Outer Continental Shelf, right, when you have a real industry with real ROIs and real wealth to be gained, then you do have a hugely competitive process, and that's why you're a bidding process. I mean, there you go for, you you've got a number of players that have markets for the product, and they're serious, and at that point, that's how you handle that. If we ever get to that stage, you want to revisit the rules and actually create a royalty structure and/or a bidding process.
Yep. And I would just note for everyone as we move forward, we can always revise the rules as well, with just like a section if we need to. In fact, we're required to review them every 5 years. Jason.
Okay, so I'd like to go back. Again, I think the 30 days is too short. I'd like to see at least 60. Otherwise, the language is pretty good. The Section 3 preliminary application process off-ramp that gives the state this ability, I think it's important to point out that the right to determine which proposed use best fulfills the policy specified in OAR, blah, blah, blah. That's important because it's not the state trying to assess the viability or the quality of the applicant, which I don't think the state necessarily does very often. You don't get involved in, well, I like this bread company better than that bread company. You just say, who's first on the site?
Development profession, you do that all the time.
You still have a first right of refusal. If somebody has doing work in a site, they do the environmental assessments on that plot of land, they get the right to develop it. So I think we're providing that here at some basic level with an off-ramp that the state has. Like, look, this company clearly does not have a history of abiding by our policies, or we just feel like they're not the right company. I get it. That's fine. The state should be able to have that authority. But we still haven't, I guess, gone back to this more substantive issue of whether or not you can go from a Section 125 to a commercial project. I don't think I heard the consensus or a solution.
You can absolutely go from 125 to a commercial lease.
But not with the first right to apply.
Well, it's not written that way right now.
It's written right now.
Is that something you all would like to see? That first, it's a matter of changing.
Just adding in the lease after the demonstration.
Blending.
Or lease.
Yeah, blending 7 and 8, or leaving it so it's fairly clear that it directs the first right to apply to the development. It's a good question. And the second question: how do you feel about extending the first right to apply to give 60 calendar days as opposed to 30?
Do we have anybody on the phone who wants to chime in on this?
Yeah, this is Rick. When you make it so restrictive, like 30 days, it sends a signal that we're not serious about it, and it diminishes the interest to get involved. And I don't think that's what we want to do. 30 days is a pretty short time. Look how long it's taken us to do this.
I guess I would still know if you're a holder in good standing, you've got that first right to apply while the authorization is in place and you're collecting the information. I think this is just towards, it sunsets after your authorization's expired, right?
So your authorization hypothetical is, I'm going to deploy 3 ADCPs in 20 miles, right? We're going to see which area has the best wave resource. But the wave resource is one of several factors that may go into your decision whether to do the project at A, B, or C, or at all. So you finish your 1-year deployment of ADCP, you've got your data, you run your numbers, you're doing whatever you're doing, and you're going back out to your financiers saying, here's the solidity of the data we acquired, and the financiers are going, okay, well, we're going to think about this. So Look, I've never been through that process. I'm speculating here, but I do know that with wind projects, they take the data from the Met Towers, they go back home with it, they compare this project to that one over there, and they go back to their funders and like, okay, here's what we've got. This one's got more risk, but this is a better resource. Does that take more than 30 days? Yeah. Before they're able to make a reasonable decision.
I think Jason makes a good point. I'd support 60 days based on his argument.
And I
Thank you.
I don't know, as someone now who, again, is having to be a regulator who has to respond to some very short statutory shot clocks, you got to process somebody's stuff. If they go to the legislature and they don't want the 60 days, by God, they want you to issue a permit within 30 days. We end up doing all these gymnastics of asking letters of extension and this and that. So it sounds, if you think that's beneficial for the industry, I can't imagine anybody's going to have heartburn with that.
Can I ask a question of DSL? Are there other authorizations you issue that have first right to apply, and what is that period?
Well, this rule had it in here already.
I know. So if we're now, I'm just wondering if there are other, besides ocean energy,
I thought Chris mentioned earlier, that's where I got the 60 days. He mentioned something else he referred to for 60 days.
For competition in these rules, in this draft.
We have a preference right, but we don't have first right of refusal. We have preference right.
We have preference right, and then our special use lease. So most of our renewable energy projects are authorized to the special use rules, except for ocean renewable energy.
But your leases are, help us understand your universe, right? It's docks, right? There are leases for docks on public lands. You also have grazing leases, right? Yeah, those are probably the most relevant to this kind of discussion, right?
Well, we have waterway leases too. And waterway leases are the ones where we have preference right. Because you can have a marina fronting someone else's property.
Okay.
And is there a period? Is there a 30
I think it's 30 days for the for the riparian holder to respond.
Yeah, so 30 days to initially respond, 120 days if it was incomplete to fix it. And that's what I think Joanne said, well, that's way too long on one end, way too short on the other. So we actually amended these rules based on that comment to be the 60 and 60 for responding and 60 for incomplete. That's later in the
60
process.
is if it's competitive, right? If there's two people vying for the same spot. So these and
so this is just to exercise after this
Right.
is expired.
Right.
So you guys are asking a lot of good questions. Give me 1 second to look at another set of rules. Just so you know, Jason, if back members are open to it, I am open to extending that as long as it doesn't make Jerry's life a living hell. Trying to track it.
I don't see it as a really big deal, but it does strike me as being kind of unnecessarily short. And what benefit do we have by restricting to 30 days? And what do we lose by going to 60 or 90? As long as the stuff is the issuance is revoked, you're done, your year's out of the water, people are able to fish, surf, do whatever they were going to go do there until you get through the next process.
Yeah, after hearing Jason's argument, I agree. If we allow a longer time period, then we are potentially kind of honoring Part 5 wish to have the phased development approach and giving the companies that have done that extra research a little bit more time.
Yes. I got to put someone else to work here so I can give
So-
Mike or somebody else to take a look at 125 and see
I
if
see
it's
the 60 or 90.
Oh, I was looking at the
I
San
think the reality is
Oh, okay.
Because I thought
there's not a huge demand
But yes,
for
I can.
competition for the space right now.
Right now.
So we're not really going to know until there's a bustling industry whether or not these have the intended
Take a look at
effect.
CPC and think for. I could.
And by the time we have a bustling industry, we will have redone this, I suspect.
My thought on that is I was originally thinking the same thing. When is this area going to apply? Two companies competing for the same spot? Come on. But just suppose Microsoft wants to put a server farm off some city and, all of a sudden there's going to be a need for power there. We know Microsoft likes renewables. I could see that potentially we could have competition for a site just because of something that we aren't anticipating now. So I think we need to write the rules with the idea that there could be some situation that generates a need.
Well, then if you do give a longer time period, then we are promoting that kind of phased approach. And
You mean phase or?
no, we're promoting the company that's done either the research there or done the demonstration project there.
I'm okay with the 60 days.
What are the timelines, we think? The demo projects were up to 5 years. What's the typical timeline anticipated for one of these research projects? Because
Well, we said
the
3 to
60
5
or
years.
30 days is going to be after it expires. So how much time are they going to have to do their research to make the decision whether they're likely going to extend it?
Well, and I don't remember if it's 3 years or 5 or special use leases, license that he's looking at.
That's a maximum, right?
That's the
Yeah.
maximum.
So,
I mean, you can get a special use for 6 months.
Yeah.
So if I'm doing 6 months and then I have the data and it's either a go or a no. So I think that's where we were kind of thinking, if you have a year to pull all your information together, you should know if you're going to move forward if you want it. But I don't think 60 days is a big stretch. Might as well.
Clarifying question.
Until we get to anything.
Scott has a clarifying question.
Jerry, is there any reason that it would be bad for an applicant, say he plans on a 6-month deployment in the summer, is there any reason he shouldn't ask for 3 years? Does it cost more to apply for a 3-year permit or authorization? Because if he does it for 6 months and it all works fine and he's in and out and he's done, no big deal, right? You can apply for 3 years, and if something goes wrong with the funding and they have to wait till the next summer, they can still in the window. It just seems like it would make sense for an applicant
They can,
to
but
apply for the
if it's
longest.
a special use license, they have to pay compensation yearly.
Okay, so
So-
there is a.
Right. But
That's not huge money.
Not much, right?
Well, it depends what it is and how we figure our numbers.
It's a minimum of 500 a year.
Yeah. So it's not huge, but if they do like a 3-year and they don't get it out the first year, we've had that. And then if they get it out the first year and they get
That's the lowest number I've ever heard reference to my industry.
Terminated. So they can
It's like how much the lawyers cost per hour.
Yeah, so we usually have a mutual termination clause.
But there's not, at
in our
least within
special
180
use
days prior.
So just for those on the phone, I think that's significant that you can apply for a longer term.
It's in here somewhere.
You can terminate there's a mutual termination
Well, you
clause
don't
in the
know.
agreement, so you can apply for a 3-year for your scientific device. You get it done in a year, you can terminate it, you're no longer paying $500.
That's all. I'll find it.
And just to,
Or you can drag it out.
or you can drag it out, but just to clarify, it's a mutual termination. So if the company wants to terminate it and we say, well, we may be getting more revenue or we may want more data from you or something, we may not terminate it. I haven't had any of those that we haven't. If it's a lease where it's longer term, some of those we will say, no, we're not going to terminate it. But the shorter versions, we usually have been mutually terminated. But just to put it out there that it could be the opposite.
But now I've added just some changes in here. This is still just a draft and run line for rack purposes only. And I don't know how you feel about extending. You talked about 60 days and didn't seem to give everyone a lot of heartburn, so that's just added in here for now. But I don't know how y'all feel about allowing the first right to apply leap from deployment of scientific equipment to a lease.
I'd like a little more time to think about that.
Yeah.
You know,
That
I
could
can
become a flashpoint. We're all going to have to become comfortable with it. So per se.
And obviously, that I structured it, you've heard my 2 primary lenses there. The way I structured it was to make a path forward, but with those stepping stones. So, but I'm open to changing. You guys represent a broad group of stakeholders here.
And just agreeing, Chris, that adding a language doesn't really support the policy of the precautionary approach. So
Can you repeat that, Scott?
if we went straight to a commercial project with the first right of apply, first right of the applicant, it destroys the concept, or it avoids the concept that we have adopted as a policy, which says a precautionary approach will be taken, or should they support, or even support, prefers to develop renewable energy through a precautionary approach. It supports the use of pilot project and phased development. It's number 5 on page 6.
And remember that, I mean, it's not that they can't apply for a lease. You know, go do your study, apply for a lease, you just don't get the first right to apply. That's what we're being asked to consider, right?
That is.
apply uniform provided by that.
Yeah, it in no way limits them to
Otherwise,
apply.
the director's form.
And folks, I know we have some time limits on
At least
first right to
180
apply or
calendars
special
prior.
use rules for
No,
renewable
no.
projects. So we put some
They haven't done something within 100 days prior to
We'll find
expiration.
out. I'll evaluate and let you know what that
Kind
says.
of already said, unless we say it's okay,
So-
they don't want to.
So my view is,
Apply?
I'm sorry.
So to clarify, this is, as I understand it, as Chris indicated, 7 is to address the research and giving first right to apply to those projects that have done the research. The second one is to apply to research projects that, again, have gotten a temporary use authorization. Again, that have put time and investment and information, provided that to the state and to the industry's development. So to me, those are steps 2 precautionary, because they are putting the time and effort in, doing the research necessary, and that's the whole point. Now, the level of the research may vary, but as I understand it, the way it's been described, when you're applying for temporary use, you go through the JART. So all that's going to be, this is going to be discussed ad nauseum as to what their contribution is and whether or not it was adequately a precautionary approach to allow them to go for the first, to do the first FRA, the first right of approval. So to me, it's beating a dead horse, but that's just me. I think adding that language is perfectly in line with the process that's laid out here and throughout this whole review that's going to have to take place for all these projects.
I didn't understand, sorry, were you saying you what added language?
The-
Like blending 7 and 8?
Yeah, the first right to apply was the discussion that we were having with respect to conducting research, and then also it applies to research projects, correct? So the scientific part in number 7, they get a first right to apply. The research project, they get a first right to apply. And if you've done, and also if you've also get a first right to apply, if you've done either of these, I understand, and then you jump and say, okay, we're ready to do a lease. Is that not how that's written now?
No.
I think
It is now, because it
Yeah.
says, or an ocean renewable energy lease.
Right, but to do, so the first right to apply, the way it's written now, is only given if they've already done, as I understand it, a temporary use authorization, correct?
yeah,
And 7.
under 8 gets you
Yeah.
from the temporary use to the lease.
Right.
Yeah,
So they've already done some work.
yeah.
If they, okay, so I'm just being, that's, to me, that's a progression as has been discussed here, right?
Yeah.
I mean, there's been some
Yeah, but some
progression.
people want to blend those so that you can go directly from 125, skip the temporary use and go to a commercial
Oh, I
use.
don't see that written that way, though.
It's not.
Oh,
People are
okay.
suggesting that change.
Oh, I'm not
Well, it is
suggesting.
now.
It is under
With the
7.
red language in 7,
Yeah.
it does bring those. It does allow you to go from a 125 scientific experiment to doing a commercial project.
But again, that's goes from is the key operative word here. It's not like, so there's a progression still, as it's described. You've done a scientific
Yeah.
project or you've done a research project.
Or no, you've
So-
done demonstration.
Demonstration project. So the way it's written now, there is already a natural progression. So if you wanted to go from a scientific project to a lease or a demonstration project to a lease, you've done some due diligence already. There is a progression there.
Yeah.
So Scott's shaking his head. He doesn't
Can
agree
I
with
just pile on just a little bit? So I do support this language as it is. So I want to I'd like to see you go from deploying your ADCP under 125 and measuring the wave environment, and then deciding that you want to do a commercial project. And if you should be able to have a first right of refusal if you've done the research on that particular area. And I want to just accentuate that the demonstration project, as defined in Section 7, is a limited duration, non-commercial activity authorized, blah, 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 where you're not allowed to have profit, right? So you're forcing a company to do a non-commercial project next, when they may be ready and only get finance if they are deploying devices that are going to create electricity that they're going to sell on the grid.
I'm sure that's the only way.
The only way there could be government grants that would get you in the water as a demonstration project where you're not really worried about how much money you make. Everybody else, somebody's going to hand them $20 million and say, here, go do your first commercial project. Sell the power to Pacific Corp for whatever you can get for it. So that's a commercial project, and you ought to be able to do that with a first right of refusal if you've done the Section 125 research on that area. That's my position on it.
Laurel, did you have?
Just if there is no threshold for how much research they have to do then to jump between, they could put anything out there and then jump.
Right, and that's my point is,
But that's
my point is that will be reviewed by the JART. They can't do that because they have to go through the JART process is my point. And
Hey, Chris, this is Rick. My 10 is up.
Thank you. You're in line.
So I understand what you're saying, and I respect that. It's just that I feel like, as Delia pointed out, we're not saying you can't go to a commercial project. We're just saying if you go to a commercial project from this science, you don't get this first right of approval, which is consistent with the state policy that says we prefer a phased approach. We prefer development first, a demonstration project first before we go to commercial. So it's not saying you can't do it. It's just saying this is how the state shows our preference. This is how the state demonstrates that our policy is we prefer. It doesn't say we require. It says we prefer it. So
But
I think this would be an example to show how the state makes a preference for demonstration projects first.
It's an example. How I would suggest that a first right of refusal after a company has done research on a brownfield or something is pretty common. So to not do it for ocean energy is a little inconsistent. Secondly, you're forcing a company, if they want to get a first right of refusal, to do a non-commercial project, which may or may not be viable. So, secondly, in terms of promoting a phased approach, the state still has the authority to say, you know what, we're not interested in you putting out 50 devices on the first project. We're interested in you putting out 5. And they can very much have that conversation. Say, look, lay us out a 10-year plan for how you want to get to 50 devices. Same way we saw with OPT, right? 1 device, 5 devices, 10, 20, 50. And any company in the next 10 years is going to be in that situation anyway, because they're not going to be able to afford to put out 50 or 100 devices. So I think that the state can implement its phased approach policy through its review in the JART process and the authorization of the permit, rather than the sort of somewhat arbitrary decision that going from a 125, we call it a scientific, it's a Met tower. It's the equivalent of a Met tower. Same thing for a wind company. That's all we're talking about in many cases here. Is putting in an ADCP to better understand how much energy is in the environment. And remember, we've been down this road once before with Aquamarine, right? So there was an international company that had some money once upon a time, and they were wanting to go this path. They wanted to deploy several 125s, but they couldn't get the first right of refusal, so they didn't deploy any of them.
They also want to bust through there's a whole bunch of them.
So clarifying
It's a very narrow narrative for what's
Okay, please.
Yeah. So Jason, what you're saying is, if a company comes and says with an application, we want to go straight to a commercial project with 50 buoys, you believe the state should be able to say through the JART process, no, you can't go to 50, you got to start with 5 or 10?
Yeah.
Okay, so that has to be written in the language that makes, and these rules, that needs to be recorded in the language that authority is there.
Isn't that in territorial sea plan?
I thought that's already in there.
We have a precautionary approach and prefer phased development. Phase doesn't mean that you have to do a non-commercial demonstration project first, does it?
Stating that the state has a preference doesn't mean that the state has the right to tell you can't do a 50-unit project to begin with.
I'm not sure that the state asserting that it has that right either, gives them that right either, does it?
What I'm saying is the state just only says that this is a preference. So how does the state show its preference? They give a little perk to somebody who does a phased approach. That's really what they do. They can't say we're not going to allow a 50-unit to start. I mean, I don't see how in the current law that there's anything that says you can't come in with a 50-unit project.
You apply for a lease, you're applying for a lease. If you apply for a lease, you're applying for a lease.
Yeah.
The state can't tell you you're not ready for a lease. You have to. Can you?
They will evaluate the project based upon the proposed number, and they're going to give a certain number to start with, and that's what the state's going to evaluate.
Right.
They can always choose to do a phased development and only put in a certain number of those to start with. But that's the company's prerogative, right? The state has to evaluate depending upon what the application specifies in their permit application.
If I can make and then we'll convene the jar today and provide you with their input.
Right.
So I don't think that as a part of the review process, we can say, sorry, we're only going to allow 10 if you apply to 50. Like, that's not in our
state's authority.
Yeah, exactly.
So, Rick,
And it wouldn't be in the rules either.
No.
That would have to be statute, so.
Rick,
Hi, I heard a comment about, gee, how much research have they done and how much should they do? I just want to make sure that we remember there's always a tendency to go through our list of basic research and questions we've always wanted answered and stick that on a wave energy project because they want a permit. And we have to maintain the discipline that only outcome-based research or research that is directly related to the project is required as part of a permit. So I'm nervous when I hear, how much research should they do to get a research grant? I see that as a slippery slope.
When do we feel like that's ever happened? Is that just a fear, or do you actually have an example of where a state agency just went on a fishing expedition and on a bunch of other research? And maybe it's true.
Let's not go there.
Before we make those claims, let's have a case in hand where that's happened.
So I've got quite a few comments on this. Walter.
No, I have a question. Is there a different criteria for a commercial, for a monitoring device than a scientific device?
A different review criteria.
Yeah, to where you put these things.
If it's done under 125,
Right. Well,
there's no jar. But we'll still have it out for review and public comment to evaluate it against existing uses and stuff.
Okay, and my only question would be is if you had a scientific device and then they wanted to go to commercial build out, what if it's in a sensitive area? Would they still get first right of refusal, or would that all be taken care of in the application process?
Oh, it's fun. So if they're not if you're talking about the different areas, like Mount Repsa or something else, Aruma, I think at that point the JART and the agency, with the assistance of our the LCD, would review the project. I think you would get the first right to apply. But
It's in a sensitive area?
we'll still be evaluating the project against the
They're not going to, they have to go through the process.
All right, that's just my opinion.
I think doesn't mean to necessarily go somewhere, and I think in the pre-application process of someone applying for 50 buoys, let's say, and they would get input through that pre-application process from the JART on how to, about basically what the JART thinks about it, and then how they could successfully, or what they need to do through the inventory and effects evaluation, move forward, and that might direct them. We're not going to tell them how many buoys to put out, but it might help provide guidance on if it's going to be a project that's deemed consistent or not.
Would they get that feedback when they're applying for their permit for scientific research, as far as, the different areas and what that means if they were to move forward?
Well, we could probably tell them if they don't, we could direct them to the territorial sea plan to see what area it's in. But no, we're not getting, we're not getting the bigger application fee to convene a joint and have that discussion.
Well, that's not what I was asking. I was just saying, if somebody's putting out their scientific research device in one of these areas where the state has shown preference to not have these devices based on the classification in the TSP, are they getting that feedback at that early phase when they're collecting scientific research that these are the hurdles you're going to have to jump if you want to get into one of those more sensitive areas? Because otherwise they're going to get this first right to apply and then go, whoa, why are all these...
If they start with the 125, it would go out for public review, which would go to all the agencies, which we would hope they would say no.
Well,
It's
I would
not-
actually hope the DSL would remind them of,
Well, and
because if they're going to be eligible for the first right to apply, then I agree.
you'd have to get the 125 first.
Sure.
And if you don't get a 125, then you don't have that first right.
Right, but the
because it's
location-
not in a location we want them.
Isn't this one of these issues that we we can't try to anticipate all the details? Look, the reality is that a company of any company that shows up and just starts wanting to deploy some ADCPs in sensitive areas, that will be brought to their attention in some manner so quickly as to be a
Or maybe
non-issue.
not. That's
No, the
exactly
answer
what Laurel
is yes.
said.
It is going to happen. Anybody that shows up in Oregon and applies for Section 125 needs to deploy ADCP.
Yes, okay. Jason's going to tell them.
I was going to
I am going to tell them. I absolutely will tell them. You have no business going there, or that's a bad idea. Because I don't want to see any failures.
We've had some real cast of characters banging on the doors here in Oregon. This is not a strange hypothetical. OPT, I remember 52 days after they promised the entire community, by God, we're going slow. Suddenly says they want to do a 200 buoy project. And if anybody wants to be bored by my conversation with Mark McCann at one point, from Mountain Marine Power, I mean, I'm telling you, I'm prepared to hear any crap from any of these guys. These are the ones that we've seen already. I look forward to the day that we have mature developers that actually are real, because I think, Jason, that they will be listening.
No, still green.
One last thing. The way this is, we'll talk about phase, or what if somebody wanted to do a 50 thing or a 100 thing. The way I think it would work is, we see it in our department. If you come in with a completely over-the-top development proposal, and then you sit and basically at a staff level, you counsel people. You know what? You maybe only ought to do 20 units there rather than 500.
It's still green.
If they say, well, screw you, I'm just going ahead, then you deny it. There you go. Well, that's a disciplining factor. And I remember for years when I was on the planning commission, we had cell phone tower companies coming in saying, no, it's got to be here, it's got to be at this location. We would say, no, it's a week. And they said, no, I call this a week later, they're back at a different application.
The green.
Or they said categorically.
It wasn't showing anything.
Oh, was it? Okay.
Rick can hear us, but the others
Rick, are you there still?
Jeez.
I'm still here.
Tell me.
Dan, are you there? Can you hear us?
You guys are coming in loud and clear.
Okay.
Somebody left.
Maybe it was
Delayed or something.
maybe it was the old one.
Andy has something, and then I want to check in about where we are one more time.
I just want to go back to how the special use licenses apply and how the territorial sea applies. When those special use licenses are considered, we do require a Part 2 resource inventory and effects analysis. When somebody is coming into a sensitive area, we would know they would have to do an analysis of whether or not their application is consistent with the policies within the territorial sea plan for that use to occur.
And what about the subsequent, like any intent for subsequent development? So what I took from what Laurel was saying is that, if I come in and I just want to put out an ADCP or something, is somebody going to tell me, okay, this 125 special use will give you first right to apply, but should you use that first right to apply, just be forewarned, this is not a good place for, is somebody going to do that?
Well, they're going to become familiar with the territorial sea plan when they apply for that special use license, and we will, as a department, make sure that they recognize that Part 5 is in existence, and so that
Okay.
communication will occur.
Okay.
And then, of course, under the flow chart and the draft rules, you would have the initial outreach and then the pre-application process leading up to an application. So, as you mentioned, the Kaizen meeting, the task, and all of that, at least the initial project description and a description of the zoning areas, we might consider that, will be discussed at that time. So, DIV doesn't have a card up. Jason, I know you're dealing.
I was ready to, go ahead. I'm moving on.
Okay, we move on. You said you had something you want to talk about, I thought.
I did. I wanted to talk about the footprint. I think that was one that a bunch of us had wanted to make sure that we were clear on. So, and if we start with 141, 140, 45, subpart 8, I have it on page 7 of the non-red line. So let's just go through.
You said 45?
Yeah. 45 subpart 8 talks about the first right to apply applies to the quarter-by-quarter nautical miles, 53 acres. I think we need to come up before, like, can we add language, just, saying that it's, that's a columnar throughout the water column, I mean, even if you just want to put a comment in there, that, the RAC has asked for, but it has come up before. So the footprint, from a regulatory standpoint, when I think about the footprint, I think about seafloor footprint, but that's not how it's been communicated with other stakeholders before, and so it needs to be clear in the rules that when a developer submits their application and they give you their footprint, you're not talking about the sea surface footprint, you're talking about the largest area that all project components must be contained within this quarter-by-quarter 53 acres.
Largest, whether it's the surface or the bottom.
Yeah.
Right. So that's why I just want to say the largest, whether it's on the surface or on the bottom. No more than 25, whether the larger of the two.
I think there's a number of different ways to go through this, and I don't know at this point if we have time to wordsmith it today. But I would like to, at least put a comment in there that it needs to be that. And I also feel like, I had brought up once before that quarter by quarter is, I think the intent of that decision was not that it be necessarily a square footprint. We've had developers who come in and they want to do something rectangular or a fan shape or whatever. So to me, it should be a reverse, and it should be 53 acres, and then the parenthetical should be approximately quarter by quarter nautical miles. Right? So does that make sense?
Here, I agree.
So you're giving them more flexibility, but we're still holding it to the same spatial constraint, which I think is what we were invested in initially. Or maybe not.
Well, the question I have is, if we mean any configuration of 53 acres, then we really need to take out that quarter by quarter, don't we? And say,
All it does is provide a rationale for why you arrived at 53 acres.
Yeah.
Or we could just say no larger than, 50. It seems really random and strange, like why 53 acres? So that's the only reason in my mind to keep the nautical mile.
Yeah, it was 50 acres, and I think it came up to 53 at a sort of a quarter by quarter. But
and I think if we had fishermen weigh in, they might say that they like to hear the nautical mile.
I don't have a tent.
Jerry Hudson. And then Jason.
So is this contiguous acreage? Or do they have like
No, I think it's
an eighth here and an eighth here?
It should say that then.
Okay.
Yeah.
Well, I think it should be, first right applies to one authorized area for holder, so it's one authorized area.
Because I know on our waterway leases, we have parcel 1, parcel 2, and they don't necessarily. I'm just asking.
I agree with you. I mean, and we have talked about that before, that we don't want it to wind up
Yeah, because if you have different.
spaced out. Yeah.
Okay, sorry. Jason?
I'm okay with this. I just,
Let me defer.
I just worry
Yeah,
about the word
something to say.
approximately, because it still implies that it's approximately 0.25 by 0.25 nautical miles, and maybe you mean for example.
For example,
And I
yeah.
know maybe Jay won't like the for example, but I mean, you're saying that it can't be any more than 53 acres, and you're giving an example of the the shape it could be, but approximately implies to me that it's somewhere
So
close
maybe
to
more.
a quarter by a
This was
quarter.
actually one of our, I thought, 6 very successful homework assignments that Scott and Rick did. So I want to make sure that I want to honor the work that was done by them and to see how they will feel about that.
I'm fine with making it, for example, to show that it doesn't have to be. I think it's a fair comment to say we may not want it to be a square box. We may want to have it aligned a certain way, and as long as it's not taking up more space, no problem there. So I think that's fine. And if you said, for example, quarter by quarter, I wouldn't have a problem with that.
But it should be contiguous, I agree.
This is Rick. I agree with Scott. For example, quarter by quarter nautical mile, you could put roughly if you want. The point that we almost certainly don't want it to be a square, because that would be a constraint on a proper ocean engineering design of the mooring and anchoring system. So, with nature, squares rarely work. So, an area of, and maybe to Delia's point, maybe it, does not have to be a rectangle, if we want to be clear.
Anybody else on the phone with thoughts on that? And hopefully you can see the screen.
Scott and Rick, are you okay with just removing the quarter by quarter and just having it be 53?
I think that
Well, I think Scott's right, or whoever, where the heck did we come up with that? Maybe, for example, a mooring anchoring footprint of roughly 1/4 mile by quarter mile.
This way.
Okay.
I'm fine with that.
Chris is making a decision. All right. And then before we leave that subject, sorry, Jason.
Scott, go ahead.
And Walter looks like he's contemplating this. Okay.
Under 9, it gets into the quarter by quarter 53 as well. And I guess I wanted some clarification, because I think this reads that the commercial facility would have to be less than or equal to 53 acres. And I thought that the limitation of 53 acres was for the temporary use and phases leading into the commercial lease, but not. A commercial lease limited to 53 acres seems.
Yeah, I agree.
Okay.
So let me read it real quick. Yes, it's just meant to be for what the first right to apply applies to.
Okay.
So the first right applies to one authorized area per holder for no larger of an area than 53 acres. So that would be, and the first right would be for the demonstration project.
So, but the sentence right before that, Chris, says, the holder in good standing of a temporary use authorization to conduct a demonstration project shall be given the first right to apply for an ocean renewable energy facility lease under these rules. And so since that sentence references both the demonstration and the facility lease, it's unclear. It makes it sound to me like the 53 acres. Oh, so no, it's the 53. Oh. So can we say something so that it's clear that the 53 acres applies? So you're coming from a temporary use limited to 53 acres and you have first right to apply for a larger facility. Does that make sense? So the first right to apply is the transition between the temporary use and the commercial facility lease. Mm-hmm. The way this reads to me right now, the facility would also be limited to 53 acres. And that's not what you meant it to say.
That's what I thought.
The first right. Yeah, the first right to apply. I mean, the lease will be bigger. It will likely apply for a bigger area. The first right to apply is we're tightening it down to a certain.
Okay. Well, if nobody else read it my way, then let's leave it.
I could see exactly what you're saying, because it could make someone on the face of it think, well, I'm only allowed to first right to apply for this area and then nothing else.
Right.
Would it be better to put in the definition of authorized area? Because I assume this definition is related just to this set of rules, unless you've taken it from somewhere else. Put the area in there and then not bother repeating it. That would lead to confusion later on.
Yeah, and that would probably solve the issues with under 8 too, if we just had, a definition for
We have a definition for authorized area.
Yeah.
So what's your suggestion?
Under definitions.
Let me ask a conceptual
That's the danger, you say.
Right. What do you want me to do?
Does the larger lease then have to encompass all or a portion of the area that was under the temporary use authorization? Or would the lease,
It doesn't have to.
but you wouldn't get first right to apply unless you're referencing the place where you had your other project.
That's
right?
correct.
Right, so the first right to apply would not apply any place.
Like
it would have to include at least that place that you did the work. And it could go outside of that footprint. Like the footprint would change, but to get the first right to apply, you would have to have the same spatial location that you were doing work in already. And this language is ambiguous as to how that is factored into.
A clarifying question to that.
Yeah.
So if that's the case, how big an area can you apply for? You say, well, we did include our 53 acre, but also we're going 20 miles north and 15 miles south.
Well, I mean, I think the company's going to have to weigh in the proposed power with the standards that are going to be applied in Part 5, and they're going to have to, but the question it remains, like if you're applying for a lease after you've done a demonstration project, I would assume you're going for larger than the area that you were just in. So, but it would have to, at the very minimum, include that area if you are using that first right to apply.
Correct.
Or else looking confused.
But the first right to apply wouldn't apply outside that area. So what is, if you didn't want that area, you'd still have the first right to apply for your 53 acres. But if it was outside of that area, you wouldn't have any rights to that area outside of that.
No, but you can submit your application for the larger area, and unless someone's already applied for it, you'd be first in line to do
Right, but to Andy's point, it wouldn't have to include that area if you didn't want that area anymore. But that would.
But then you lose first right.
Yeah.
For that
It's
area.
interesting.
Yeah.
But I don't know why they
First
would.
right to apply only applies to that specific geographic location where the demonstration worked. And once you go outside of that, if somebody came in and applied for a project immediately adjacent to your demonstration project, that could throw a monkey wrench into
You wouldn't be able to-
the whole right
They would
to
have-
apply in that space.
Yeah.
Well, the same exact issue exists, and we have not fixed it at the federal level. If you get a FERC preliminary application, preliminary permit, it's just a placeholder.
Right.
The company has an incentive initially to only pick a pretty small area because you're paying by the studies you'd have to do, and the answers you'd have to provide would be for the whole area for your project. So the companies are choosing to select a small area, and exactly what OPT did originally. But there's no way to protect the larger area unless you actually submit the initial preliminary permit for the entire area. Even though you're only going to study initially that ADCP is going to be here in an area that's 50 by 50 feet, but you're going to want the area around it. So that's exactly the same issue. So I was just kind of playing around here back under 8. I hadn't actually drafted anything, but basically it would say something like, third line, be given the first right to apply for a temporary use authorization for an area including the original 125 lease space in an area contiguous up to 53 acres. You get a first right of refusal on the initial area that you lease under 125 and up to 53 acres of contiguous space.
Okay with that.
Around your
around your original,
scientific device?
around your, wherever your lease space was, your 125 lease space was.
But then DSL would have to put constraints on any subsequent applications that came in within that first right to apply area, even if it was outside the authorized
To
area.
buffer the 53
Is
acres.
DSL going to do that?
Just to add quickly to JC's narrative, something that I recall from 9 some odd years ago with OPT, and at least the first side of things, that the general observation was any Tom, Dick, and Harry can take out a preliminary permit because there's hardly any expense, and that's what site banking, because there were no costs to it. It was really ridiculous, and that's why that was such a shadow over how do we actually make this work if people are ready to do something. It was my observation, I think others who were around at the time, when you saw what OPT had to actually do to start proving up on a preliminary, the NOI pad, meaning they had to hire people with skills like Steve Kopp and start actually doing work, that started to become like a $750,000 exercise. And that I think that really separates the men from the boys, because, and I hope to some extent that's helpful in terms of understanding that there are other disciplining factors on people just willy-nilly going ahead and that's why these due diligence requirements are there in the preliminary permit. That if you're not moving to the NOI pad, FERC knocks you out. It says you have to you get it surrendered. So I don't know if that's helpful.
And that same scenario is why OPT expanded from the original preliminary permit to the much larger project, because they wanted to protect not just the original preliminary permit to study area for their one buoy, but the area around it where they were going to ultimately deploy 100 buoys. So that's why they submitted the secondary application, so they can encompass the area around the initial area. This language, if we could anticipate that, we can say,
well, based on their behavior and actually being part of so much of it, I think part of that was also the theater of OPT pretending they were really ready to do something on a big scale to attract money.
that was OPT talking to their shareholders that we have a plan forward that makes you worth your investment in our company. And that's perfectly fair for them to do. Whether or not they did a good job of it is an entirely different question. But we can expect companies to do that.
To the extent sellers want every minute.
Agreed. And yet they're still in existence. But here we go. If we look at this, we could say, again, oh, you got it. First right applies to one contiguous authorized area per holder. You have to say you have some reference to the original lease, though, right?
Well,
Or the
holder.
My question is, do we specify anywhere in here that it's an exclusive use? Because we have leases and we have other leases on top of them. If
Say that
they're,
again? You do?
we do.
Oh.
If they're compatible uses.
Okay.
And I don't,
Give an
we
example
have
of
an
how that would
area?
happen. Like,
The LM has all kinds of examples with multi-users all
Yeah.
over.
but in the
the
ocean, how?
it's,
Time out.
Okay.
Dan, are you still on the phone? Because I want to give you an opportunity for public comment, or anybody else who's not a member of the RAC that would like to submit public comment.
I am still on the phone.
there you go.
Dan, you are up.
I have a couple of comments. One of which was the discussion that was happening about deploying scientific instrumentation rather than devices themselves, and that gave me a lot of concern because OSU have multiple multidisciplinary research projects going on where we have scientists deploying instruments that we use the data for planning wave energy converter deployments, but it's not necessarily our project. So I think there's somewhat of a unclear gray line there that you folks have to be aware of. I would hate to see that everything that OSU does or other universities does as far as ocean research gets classified as wave energy
research simply because that data might be used by us or others in the wave energy interest industry. So I think that's something to be aware of. Later on, you guys were commenting on the defined area for projects, 53 acres, which or whatever, but which is completely bizarre to me. But one of the things we were told when we were looking at our PMEX set site, which is outside the territorial sea, was that fishermen really like a regularly shaped area, like a box, because from a navigational point of view, it's going to be much simpler for them. And, you know, that's part of the reason why we went for a 2 nautical mile by 1 nautical mile area for sets. And the last point I want to make is, as far as the leasing and so on, again, we're outside the territorial sea, but when we were going for our BOEM lease, we're only looking for 2 square nautical miles. BOEM highly recommended that we put in a lease application for a much larger area to give us flexibility. So I think, I'm not quite sure whether this is the right number, but I think our lease application was for something like 35 nautical miles, square nautical miles. With the idea that that gave us flexibility to finalize and move our final site within that without having to put in a new lease application. We didn't have to do all our surveys within that area. We could focus that. So I think that's part of the problem that Windfloat ran into. And you know, it's the area you're trying to define isn't finally defined until you can actually do some really good marine surveys and site characterization. So those are my points. Thank you.
Thank you, Dan. Those are good comments. Okay. Y'all probably know what time it is. It's 2:20. Folks? Yes. Is there anyone else that would like to provide public comment? With that said, we're going to continue on here with a quick check. It's 2:20. How are folks doing? You want to wrap it up for the day? I got
to go in 10 minutes, and that might be a blessing. So
you've been great. We always appreciate your help. I can stay a little longer. I don't want to make you guys stay because I'm going to get back to Salem with your staff. There's a lot to chew on still. We're still got some. We can either continue on, or I would like to hear your major topic or priority that we did not get to today, so I can work on it later.
Thank you.
And maybe you guys could get redline versions. Did I send you Word documents or PDFs?
Word. No. You sent PDFs.
How about I send the rack of Word documents and you can get me your comments?
Oh, it doesn't matter. Comment PDF or Word.
Word
comment either.
Okay.
Yeah, but it's a lot nicer to provide a suggested edit in Word than it is in PDF.
Okay, so let's go around the table and the phone real quick. We've gone through. So we got to discuss scientific experiments and first rights to apply today. And the footprint a little bit. Thank you. Give me your next number one topic or priority for the revision. And then I will send you all a Word document if you get me additional comments in the next couple of weeks. I'll try to consider that and put them into another draft. So we're starting with Andy Lanier.
Honestly, I haven't had time to go through this all the way, but I would make sure that any conversations you have with the research community about financial assurance are
know in past meetings, we've talked about the makeup of JART, et cetera, et cetera. Is that, are we returning to that, or were we through with that, or were we really about, is that part of the process? Or?
Well, we incorporated JART, the language from Part 5, from the JART and its composition into the rules. And then flushed out the process more. So we can take a look at that.
So, okay, so look at that, and then if we have issues, then we take it up at the next meeting.
Yeah. And frankly, for the red line version, I tried to put in the justification and comments for a lot of changes, and I'd be willing to discuss things that were sort of set by legislation if you want. They obviously didn't rise to the level to jump in priority, to jump up above some of these other issues today. So take a look at the comments for the rationale for a lot of the things I added. I'd be happy to talk with you either in a later RAC meeting, if you want to give me a call or have me call you, we can discuss a little bit of that too. Scott?
Financial assurance by developers for removal of structures, devices from the water at the end of the project.
Okay.
And so both the financial aspect of that, making sure that there's bonding or something in place, but also the compliance, the method to ensure that compliance is taking place.
So compliance monitoring.
Yeah.
Okay. Let me touch base with you before you leave today. Sure. On that. Jerry, you're the one who has to implement these. I'd like to hear your 2 cents as well.
Well, mine too is retrieval and recovery and getting the assurance in place in case the company or scientific institute leaves it.
Yep. And I know we discussed briefly I tried to summarize my meeting or telephone call with Dr. Haggerty. We've mentioned Enroll a few times in earlier meetings. I don't know if we've deemed it sufficient yet, but they have been able to, they've attained an insurance policy that includes retrieval, decommissioning, and retrieval. It's pretty well written to me, but we haven't flushed it out yet. So that could be another successful option for folks. Joanne?
Yes, I have 3.
3.
We haven't got to the definitions. I'm particularly concerned about the definition of nonprofit, an accredited nonprofit research organization, and also how not-for-profit is defined also.
Okay.
And composition, and the reliance of those bodies for facts.
Okay.
And then the review that includes both the department and JART with respect to what that review would entail. So I know what the review from the department would entail, and I just I'd like clarity on based on what is my comment. Review based on what?
The initial review?
Yes.
So early on. Okay.
Just because these 2 bodies are reviewing it, I want to make sure that they have criteria that they're reviewing it too, not just open-ended like that. And then the third is with respect to the applicants and what the expectation of their application analysis included in there. Right now, it's only stating that they need to include analysis for statewide planning goal 19 and the Ocean Resources Management Plan and the Territorial Sea. Well, this industry was instigated and proposed to be supported to expand the economy of the state. So there are other statewide planning goals and policies that apply also. And I don't think that a review is complete unless those other planning goals are included in that analysis and balanced.
Okay.
So those are my highlights.
Thank you. Walter?
Mine would be more on the navigation side. Rick brought up area to be avoided. I would want to know what the state would determine whether or not the developers said they don't want anybody going through there and how that would jive with and I think that has to do with the footprint also. The other would be removal. And the other would be just a dark process on membership, how it's going to be determined.
Thank you. Laura?
Assuming you integrate the discussions we had at lunch about Ocean Shore
Yes.
in there somewhere, then I think
Some reference
to
Ocean
that.
Shore being required.
Some sort of
if it
cross
crosses the beach zone, and then if it crosses the beach zone, there's local language review. What's it? The territorial sea. Okay, and not necessarily reference.
And at the very least, a lot of that's just to guard the right of conditional use houses.
So, again, I don't have any big issues, but I tried to limit myself to just a few little comments here. One is under definitions 3B, you refer to any required buffers, exclusionary or safety zones. What are those? Where are these buffers showing up? I've heard buffers in reference to ecological features. I remember that from the TSP. But so far, I don't know what basis there possibly is for exclusionary areas, safety zones. Where's this language coming from? 2, the application requirements on page 10. 3, it says the applicant shall include with their application an analysis of and any relevant supporting documents or studies that demonstrate how the use requested for authorization will comply with ORA 141, the requirements of statewide planning goal 19, the Oregon Ocean Resource Management Plan, and the Territorial Sea Plan. Jesus Christ, that's a massive research project for a company to draft a document that would respond to all the policy and issues that are included in all those. Maybe that's how business is done. I don't know. But that strikes me as like, wow, I can spend a month writing a document like that easily.
Well, that's the point I made. It's not just those. Ironically, it's not just those goals that would apply to such a project in the state.
That's a pretty massive writing job for somebody.
It is. You have to hit the high points. That's my point.
Yeah, that's what I was thinking. Could you create, if you agree in the JAR process to things you do need to address? Otherwise, you start with territorial sea plan. You're like, okay, it's phase 1. You start reading, you're like, dun dun dun. How do you begin to address it?
This was existing language, and we have offered something in light of that. But there is a part 5 that's been established since then, and maybe we could streamline that to reference part 5 instead of all of that.
Okay. Computation of annual compensation. There's that crazy formula in there.
Yes.
Seems a little interesting. Curious where that came from. And you're basing it upon what the person's claiming to be the nameplate capacity of your device. If my device had a nameplate capacity of 1 megawatt, I'd sure tell you it was 100 kilowatts, since that's what it's based upon. Why not just based upon what last year's revenues were? If you're going to charge a fee, just based upon what value of the energy they sold.
What if they didn't sell it?
Then it's not a commercial project. You don't have any fees associated with it.
Just base rent.
It's the director's discretion.
Yeah, just
So we could leave it to that's something that I was hoping to discuss. It came from a BOEM regulation, as I think it says in the comments there.
Yeah, it's just,
I would more than welcome, a homework assignment if you would like some suggestion for something that's fair and predictable.
Yeah. I mean, hell, you don't have to predict anything, just based upon what last year's sales were. You still got fees associated with the removal fill, and you still have fees for the application.
I think you probably still have a flat acreage fee.
And flat acreage fee. So if they're not selling power, if they sold any power, you base the cost for this, what was it called, an operating fee, based upon how much power they sold. And that should be something that's very well documented from the previous year. I would think, right? You're selling power to a utility, and somebody's going to know how much power you sold them.
So, homework.
I will.
Make a suggestion, and I don't know if someone wants to, if you want to bounce it off.
Okay.
Else on the rack too, as a peer review. Besides myself, please send it to me.
And then,
So send it to everyone. There you go.
I'm sorry, say what?
Come up here with a suggestion for a different compensation schedule and send it to the back. You sent it to me, I'll distribute it.
Okay. And then there's this weird language. It shows up, I circled a couple times. It's under page 10, subsection 5, unless otherwise allowed by director, a fully completed application for temporary use authorization, blah, 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 shall be submitted to the department 180 days prior for proposed installation, construction, operation, maintenance, and removal. So is there a reason for including this reference to removal? So you're going to have to go through, one of these requires you to go through the pre-application process. So you have to go through the pre-application process for removal of ocean energy device?
We can state want to review the plan and make sure that everything is...
Fair enough, but right now it tells us go look at the pre-application process for anything that's a operation, maintenance, or removal. So a temporary use authorization or a demonstration project or an ocean renewable energy facility lease for commercial operation shall be submitted to the department 180 days prior to the proposed installation, construction, operation, maintenance, or removal.
Okay.
Installation, yeah. But you got to submit something to maintain your device. You're going to submit something to... Yeah. Ultimately, the removal plan, clear enough.
Sure.
Why'd your thumb red? Oh, I'm sorry, I thought you were bleeding.
No, I'm going to say something though. So I love it. I love the comments. I'm sorry we didn't get to all of them.
That's all right.
Let's get to, I still want to get to everyone's high couple of points that we didn't get to. And I will send you all a Word document today before I leave. Then give you a couple of weeks to get your comments to me on that. Jason, do you have anything at a high level, real burning?
No.
Just before we start getting to wordsmithing a bunch of sections, I'm sure people have comments, phrasing comments on the number of sections. Okay, Delia.
Other than what we already got to, there's several places in here that talk about JART roles and responsibilities, and so I just want to make sure that it's phrased in a way that it's actually going to work. And so I had a couple comments in here and clarifying points about that. So JART roles and responsibilities. And then wanting to make sure that it's consistent with all of our existing policies, as well as the concurrent efforts we're doing on the removal fill side.
Okay.
So I had a couple concerns about that. And then just a couple small clarifications about the footprint that we talked about today.
Okay.
Yeah.
Thank you. Rick.
Thank you. My closing thought is that I agree with both Dan and I agree with Scott and myself from our homework. Mariners would like squares, and if you're going to give them a square, it's got to be a bigger square. Naval architects and ocean engineers need flexibility to design for a properly designed mooring and anchoring system, and it's almost certainly not a square. So you kind of either work it one way or the other. So it's a balance. But if we're going to keep to a minimum area, it needs to be non-rectangular for the safety of the mooring. I think that's all I've got.
Thank you. Justin.
Yeah, nothing significant to add from what I've already heard. I think just echoing the flexibility aspect of it, and I think the example Rick just gave is a good one, and that Dan tried to lay out in detail as far as what happens in the real world. So beyond that, nothing significant that I haven't heard already.
Okay. Hugh?
He's got the audio.
What about Charlie was on too?
Charlie?
And Nick.
And Nick. All right. Sounds good. Well, thank you, everybody. Really do appreciate your time. Our next meeting will be January 17th in Salem. Does that sound right?
At DSL's office?
At DSL?
And hours? 10 to 2, 10 to 4.
We'll pull up the calendar here real quick.
All I have is all the L.
And it's 8 to 5. Tuesday.
Pretty much. Yeah, that would probably be right. That makes sense.
Oh, 10 to 3.
I think we said 10 to 3.
10 to 3
Uh-huh.
on January 17th.
Uh-huh. That's the,
And you're getting us lunch, right?
I don't know if that saves the
Well, we're saving travel.
I can buy snacks at least.
Taco Bell for
I baked brownies for my meeting yesterday. Cranberry brownies. I had to bring them. I
Baked brownies?
baked brownies, yeah. I had
My son
to do a meeting just like this out.
We can bake brownies.
Baked brownies and bring them.
A brownie
We're
competition.
trying to bring donuts. We will have the Adobe Connect. I don't know how well it worked at the conference call, and it shouldn't be. So it should work better in our building. Fingers crossed. I'm going to send you, before I leave today, the clean track change version that I was working off of, and I would like your comments in follow-up to this meeting. I'll be listening to the tape a few times before I go on vacation. If you can get me comments in the next couple of weeks, or let's say by Christmas, written comments, that would be wonderful. I'm going to assume that, well, you can bring it up in your track changes version, but if a lot of things that I added based on statutory changes, I guess I'm going to kind of go on the assumption unless you flag it in your version that you're okay with those additions or conditions.
Today's changes.
Yes, well, I didn't receive any comments from anybody ahead of the meeting.
You didn't ask?
So.
No, we don't have to. Did you say where it was going to be in Salem, but is it at your building? You
DSL.
already have a room?
I think I have a room.
Yes, it's in our real quick room. In the
Yes.
probably, yeah. Open.
Where are you going on vacation?
Oh, just out of San Francisco, California. I didn't ask for that. No. Okay.
Everyone have a happy holiday.
Yeah, you guys all have happy holidays too.
We had to play in the snow this winter. I haven't seen the snow for a couple of winters. Actually, I got snowed out yesterday. I got snowed out yesterday morning. And I got snowed going across the Cascades to bed in November.
Have you been to
Yeah,
that meeting before?
there's definitely some out there.
Plus,
Sitting in the back.
No,
There was white, there was white in Newport today.
it'll be my first one.